calling 2022 CR 10214B, State of Texas versus Gracie Segundo. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Javier Oliva and Bradley Bellis for the defendant.
Are you Gracie Segundo?
Yes, ma'am.
All right. According to the plea bargaining agreement, punishment is to be assessed at 7 years in the prison. There's a $500 fine. The state is opposing your application for deferred adjudication. They're recommending community supervision, and there are items to be taken in consideration. Have both parties had a chance to review the PSI report?
Yes,
Any objections to the PSI report, state or defense?
Judge, so there are some errors on the PSI report that we wanted to bring to your attention.
Yes.
So it lists the offense date as, I believe, November 16th of 2021, when in reality, the offense date that's on the indictment is October 16th of 2021.
All right.
And it lists that in the criminal history. There's an assault that was in the criminal history that it makes it seem as if they're two separate offense dates.
Okay.
And then I think in the towards the back of the actual statement itself that Ms. Segundo gave, there's a portion where it's talking about the co-defendant and that he's charged with ag assault deadly weapon. It's assault SBI. It's the same offense.
Okay.
We just wanted to make sure you were aware.
All right. And the court is also in receipt of victim impact statement. And the court reviewed that without objections from the state or defense. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
And the court is also in receipt of letters that defense presented on behalf of the accused. And there were no objections to the court reading those letters. Is that?
The PSI report may sound procedural, but this moment matters more than people realize. Errors in offense dates and duplicated charges aren't just clerical issues, they shape how a defendant is perceived at sentencing. At the same time, the court confirms it has reviewed the victim impact statement, and that's critical. This isn't just about what happened, it's about how long the damage lasts. When a judge confirms on record that victim impact materials were read without objection, it signals something important: the harm is undisputed. No one is arguing whether the injuries were real or serious. The debate now shifts from what happened to what should happen next. So let me ask you, when the harm is clear, how much should background and character weigh against it?
Correct, state and defense?
No objection, state judge.
All right, so the court has reviewed all of those documents.
Your Honor, I also raised that part of the agreement of coming back today was that the misdemeanor that occurred on the same day of this alleged date was to be taken into consideration with CC County Court 4 case 69-3701.
Yes, and the court does have that as a part of the plea bargaining agreement.
And Judge, just to kind of expand on that, I believe as an additional part of the plea agreement was that she was to take responsibility for what happened as a part of the TIC.
Yes. Okay. All right. So my understanding, the complainant in this case is Rebecca Martinez.
Yes.
All right. And is that the Rebecca Martinez who's on the fourth court?
Yes, Judge.
Yes, sir.
All right.
President of the courtroom.
So that everybody can be aware, I do know Rebecca Martinez. She's never been to dinner at my house. I've never been to dinner at her house, but I do know her. We are colleagues. And when I see her, I say hello. She says hello to me. I may ask her about her day. She may ask me about my day. But I will tell you that my decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this, now is the time to say so. State?
No, Your Honor.
Defense?
Your Honor, I have all the confidence that it was fair and right.
This is one of the most delicate moments in the entire hearing. The judge openly acknowledges knowing the complainant professionally and immediately addresses potential bias. That's not accidental. Transparency here is essential because perception matters just as much as fairness. By inviting objections on the record, the judge is effectively saying, if anyone believes I cannot be impartial, speak now. Both sides decline. That decision locks this courtroom into moving forward under her authority and eliminates a future argument that the process itself was tainted. This is judicial ethics playing out in real time. And it raises a serious question for viewers. Even when a judge does everything by the book, can justice ever look neutral when power dynamics are this close?
this case. So no objection.
All right. So are there any witnesses that anyone wishes to present, state?
So the state doesn't have any witnesses. The main thing that we wanted the court to be aware of was the statement from the complainant,
All
which the court has already noted that they read.
Yes. Defense, any witnesses?
Your Honor, other than my plea to you and our arguments to you before considering sentencing in this matter, I will be speaking and Ms. Segundo may say a couple of words, and Ms. Segundo's parents are present in support of her today. They can stand with Mr. Is standing here in support of her today.
All right. Thank you.
They will not be speaking.
All right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right. You can lower your hand, state your name for the record.
Gracie Segunda.
All right. And with regards to County Court Cause number 693-701, the state is taking that case into consideration, but to that case, how do you plead?
No contest, sorry. I'm just so nervous.
That's okay. So in order for me to take that into consideration, she will have to accept full responsibility for it. So a no contest plea, I can't accept that because I don't have any police reports in regards to that. So she will have to enter a plea of guilty to it and accept responsibility for it. And then the state will tender dismissal to the court and the court will sign that. I don't know if you want to discuss that with her.
We'll go ahead and proceed with a guilty plea, Your Honor.
All right. So the County Court Cause number 693-701, how do you plead to that?
Okay.
All right. And state, do you have the dismissal
Yes,
for the
Judge.
court in that cause number? All right. So the court then will hear argument. State, you're opposed to deferred adjudication?
Yes, Your Honor. The reason why the state is opposed is because of the nature of the offense, the actual underlying facts. There was an assault that occurred where the resulting assault it created a lot of issues for the complainant. She was severely injured. Her life was severely impacted from that date forward, and she still feels the impact to this day. It's something that was senseless and didn't need to happen in the first place. So that's why the state is opposing deferred and is asking for probation.
Defense?
Your Honor, we're here because one incident can't define a person for the rest of their life. And this is very serious, and no doubt we take that very seriously. This is a felony charge. It's a felony charge that carries a very significant penalty. But Ms. Segundo, I think, has demonstrated a respect not only to others, but to life and to animals, and in her work and her career, and taking care of pets. Rarely do I have an opportunity to where a client will provide 32 letters of reference about how wonderful she is with caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. And she's having to raise 4 children on her own, ages 15, 14, 12, and 10. As a single mother, she has to be involved in their school activities and support their activities with FAA. And a felon cannot be associated with children and be around them in school activities. This would drastically impair her ability to be a mother to her children. And so she's really fighting to be able to continue to provide the love and the support of 4 children that need their mother so that they can become better than her and have a future. She lives in Houston. She leases a home. She's lived in that home for 3 years. She has good family support. As I've said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old. 2 years this week, this happened. And it's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She's appeared in court. She's traveled from Houston to San Antonio. She has fully cooperated. She has weighed all of her decisions and sought not to seek a trial, but to put the decision on deciding her future on you. And she made that decision because she felt that was in her best interest. She does receive some child support. She is willing to do everything and anything that it takes to give her this opportunity. I explained to her that deferred adjudication is a double-edged sword. You may think like, you're not going to be subject to a conviction, but in actuality, you are subject to all the conditions and behavior for 7 years. We're asking you, Judge, to give her that chance, to give her the opportunity to prove to you that this one incident does not define her life or who she is or how she is as a mother or how she works. This case was very regrettable, and it should have been a day of celebration. It was after a football game, and she was acting in defense of another. She doesn't know the victim in this case. She doesn't know the judge. She never knew who she was. And I sincerely believe that just because she's a judge doesn't mean that this case should be treated any different than any other case of any other person who comes to this court and gets justice, because she should get an opportunity to do it. She's willing to do the urine analysis. She's willing to state no contact, and she's had no issues in the last 2 years with the defendant, the complainants in this case. She's willing to take anger management classes. She's willing to do community service. She's willing to do what it takes to give her the chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought of. It was just something in a reaction and defense of someone that she was with. And for that reason, we think that she should be given an opportunity to earn the right to be able not to be a convicted felon. The amount of restitution in this case, I think we've agreed to, that was presented before the court, was $2,416.29. We fully agree to repay that. We will work hard every day to pay that back. But in this working community and in Houston and San Antonio, mothers every day have challenges. And we regret that this happened. And I know that she sincerely has nothing personal against Ms. Martinez or her husband. She wants to do what's right, but she also wants a chance, Judge. And I'm asking you with all the fiber of my body to give her that chance. And I will make sure and work with her that she will comply with every condition, so she will never be back here before you regarding any violation or any condition of this case. You want to say something?
Yes.
All right. Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So for me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on the fact that she's a judge. If she were the president of the United States and she were here as a complainant, I wouldn't put weight on the fact that she's the president of the United States. I'm just dealing with the facts here. And my job is to look at everything objectively and not outside noise, not what people's occupations are. You understand? So I always reread everything and reread police reports and the PSI report, and I've read the letters. I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator, to it's a brawl. So explain that to me.
I mean, it just, I couldn't show you.
I mean, there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator.
Mhm.
Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. And there were already some people on there. I don't understand how an elevator is at capacity, people need to get off or more people can't come on, how that ends up in a fight.
Yeah, I couldn't tell you how it started. I just, somebody in my party was getting into it and somebody hit me and I just reacted. And unfortunately, you know, I feel bad and should never have done that. Shouldn't have got to that. It just happened really quick.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit, and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight, and then you decided to get involved in that fight.
You know, I went to go and try and pull my friend away, and then like I don't know, it was just a bunch of people, and somebody hit me, and I just reacted.
Your Honor, if I could clarify, I think the facts is this is a COVID era situation in the elevator. These elevators can accommodate 18, 20, 22 people, and they were limiting it to 7. And as people went into the elevator, the policy and procedures of the elevator operator of not allowing people to come in once they met capacity. They were in the elevator, they were asked that there was too many in the elevator, and then people had to decide who's getting off, and they asked who she was with, another man and another person, to get off the elevator. That person said, I want to talk to your supervisor. That individual entered into an altercation with the victim's husband that spilled out of the elevator onto the floor. She came in assistance to that man, and that's when she was hit, and that's when she struck the victim. That's stated in one of the reports here that was provided to you in the PSI. And she did not go in there to fight. She didn't go in there to look for someone to fight. She was trying to get someone off of her friend. And in the process of that was struck, and she injured Ms. Martinez. And so it's regrettable, Judge. There's no doubt about that. And this incident happened in a matter of seconds. And that's why we're here 2 years later doing that. And in addition to that, Judge, there is a civil suit in this case where the parties in this case are seeking $1 million in damages against my client. And so this case will not end today. It will continue in a civil matter with a lower burden of proof, where she will have to defend herself in a civil cause of action for money damages.
And Judge, just to clarify from the state's end, I would disagree with the characterization of how the incident started. The party was already on the elevator. The complainant's party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off the elevator. They were asked not to enter.
They were in the elevator.
And that's what started it.
And I also have a copy of the lawsuit that was filed this week before the sentencing, where they're seeking $1 million damages in civil lawsuit right here. You want to see it, Judge? It's public record.
I would object just because relevance.
So lawsuits and filed in the city court. That's a copy from the courthouse.
All right. Unless there are some facts that are listed in the
It pleads the
lawsuit.
whole case, Your Honor. Exactly what you're talking about is pled in the civil suit.
I mean, if that document has facts that somebody has, alleged facts that somebody has presented, that's a different rendition from what's in here, then the court will.
It does not, Judge.
All right. So,
Just to let you know, there is a civil suit.
all right, then the objection will be sustained. All right. Anything else from either side?
No, Your Honor.
No.
All right. I've read your letters that were presented, and it appears that, other than this one incident, you're a great person. But sometimes sentencing, not sometimes, always sentencing has to do with punishment, rehabilitation, and basically whether or not someone should go to prison or not go to prison. These are all things I have to think about. You understand? And so I have to weigh certain things. And the things that I'm weighing are the fact that there were people in the elevator and you were asked not to get on the elevator. Is that correct or is that not correct?
You were on the elevator.
Your Honor, the elevator's door was open. They entered into the elevator and they were asked, there were too many in the elevator, and the elevator operator asked people to voluntarily get off.
All right. So there were already people on the elevator. Then you got on the elevator and you were asked to get out.
Us just walked in at once.
All right. And then you were asked to leave.
They said we need people to get on.
All right, so why didn't you just get off the elevator? That's what I don't understand.
You didn't decide that.
Yeah.
She didn't decide that. It was a person that she was with, Your Honor, who is a defendant in the case that's in another court.
So my question is though, if there are too many people on the elevator, and let's say you get on the elevator, it's a group of you, the elevator is already filled. I'm assuming, and correct me if I'm wrong, people were on the elevator, they had not met maybe their 7-person capacity. And then you and your group come on, and because of the number in your group, they've exceeded their 7-person capacity. And then they're saying, you all need to get off the elevator and wait. Why not just get off the elevator? That's what I don't understand. Even if you're with somebody in your party who says, I'm not getting off the elevator, why didn't you just get off and I'll wait for the next elevator? I'll take the stairs. I don't understand.
We had already gotten off 2 floors, so we said like we've been waiting, but we didn't want to be the ones to get out.
And was alcohol involved, or people just don't want to take
It
the
was after a
stairs?
football game, Judge.
Estate, does anybody want to? I know the complainants are here. Do they want to
No,
say anything to the court?
no, Your Honor.
Okay,
Oh, Your Honor, may I have one moment?
yes.
Your Honor, I'm going to call case question.
Okay,
Your Honor, he's not a victim in this case. Why would he come to?
I mean, we'll see what he has to say. I don't know if he's a relevant witness or not, but if he were present at the scene.
You know, I would think that the person involved is the one who's, in this case, is the one that would need to address it. He's had his day in court. He has spoken before the court. I don't see why he needs to speak in this case at sentencing.
All right, you can call your witness.
State calls David Martinez.
All right,
Your Honor.
you're welcome. If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
David Martinez.
All right, state.
Mr. Martinez, from your memory, what occurred on that day?
On that day, we were in line to get into the elevator. The capacity of the elevator, of course, as I mentioned, was 18. But because of the COVID era, there was an elevator attendant there. She said only 8 could be allowed in. We were 3 couples and 2 children, which were a total of 8. As we walked in, we were already in the elevator. They decide to come in behind us. The elevator attendant told them they need to step out. It's full. They had been intoxicated. Her friend.
Objection, speculation.
Overruled.
No, they were
No.
intoxicated.
Yeah, here's the thing. You cannot address the attorneys. Once an objection is, no problem. Once the objection is raised, just stop speaking. I'll make a ruling on the objection. And then I'll let you know if you can continue or not, if you have a question about that. That objection will be overruled.
He came in, stood at the door, prevented the door from closing.
Objection, Your Honor. I just asked for clarification from the ones. I don't know who he is.
Which he are you speaking about, sir?
Her partner, there was 2 gentlemen, which was the initial one that started arguing with us. And her partner that she was mentioning that walked in, and they were not, we were already in the elevator already when they decided to block the door from closing. Can't recall the individual's name, but it was a younger gentleman that was with her. He proceeded to argue with the elevator attendant about, letting them in or not, that it was BS, that they cannot be let in because there was a lot of room. And she told him they had to leave. He continued to argue with her, and he said that he wanted to talk to her supervisor. And she says, if that's the case, she shut off the elevator. And that's when words were back and forth. They continued berating us. She was cussing like a sailor, as well as the other ones. We kept quiet, and they started again arguing with us. We stayed in there. The kids were already getting terrified with what was going on. They started crying, and they continued with their vulgar language. And I just told them one time, that's it. If you, the gentleman that was with him, got upset. He literally from the outside ran into the elevator, knocked us all over, and assaulted all of us in there. I grabbed him and I pushed him out. It was not the individual that she says was in there. It was the other individual that was with him that probably hosted them to the game. And he and I went outside, and after that, what?
From there, sir, is that where everything happened?
Correct.
Pass it with this judge.
Any questions?
Mr. Martinez, I'll just start right from leaving the elevator. So by the time that you set foot out of the elevator, you're in the middle of a physical altercation. Is
I
that right?
was, yes, while I was on the ground.
Okay. How much were you able to perceive about what was happening around you while you were in the middle of that?
Well, I was
altercation?
on the
If you
ground.
let me finish my question.
All right, it's,
One
I'm gonna talk.
So my question was, how much were you able to perceive about what was going on around you during the middle of that physical altercation?
And I was not able to see when I was in the ground what was taking place after that.
Okay, and we can agree that the incident in question, the basis of this criminal case here today, is something that happened during the middle of your physical altercation, right?
While I was on the ground, yes, and then afterwards, I did get up and partially saw my wife on the ground with a bloody nose. She was in a daze, and I asked her what happened, and I told her that she got hit. She said, "Yeah, I got hit multiple times." And I said, "Well, why didn't you defend yourself?" She says, "I couldn't because I was being held down."
Can you say for certainty whether or not Mrs. Segundo was acting in defense of another whenever she got involved in this incident?
I'm going to object to relevance.
All right, that'll be overruled. You can answer the question if you know.
I can't say that, but I can't answer.
Oh, and I understand, Mr. Martinez, the want for justice on behalf of the injuries for your wife. I just want to make sure that we're also serving justice here for Mrs.
Absolutely.
Segundo today based on her amount of involvement in this incident. And
There was
so-
no, go ahead. I'm sorry.
Go ahead, please. finish.
No, there was only two other parties involved, three parties, and the individual who was with me had already left. But it was only her left with her friend. And there was nobody else around. There was people watching, nobody was getting involved, but
When the complainant's husband testifies, the tone changes. This is no longer abstract. Children were present. Fear was real. Injuries were visible. And perception narrows during chaos, which complicates intent, but not outcome. What stands out most is uncertainty. Even the witness can't say definitively who acted in defense or who escalated first. And that ambiguity matters. Because when facts blur, judges default to results. Someone was hurt badly. That harm didn't require malicious intent to be life-altering. This is where sympathy and law part ways.
they were the only ones actively, physically getting involved.
But, and I know we started this conversation based off what's happening when you're leaving the elevator. Prior to the altercation and leaving the elevator, would you say that in any way Mrs. Segundo was the instigator who was trying to start this situation? I have no further questions.
All right, any other questions?
Nothing from the state judge.
All right, thank you.
This is it.
All right, any other witnesses?
No, Your Honor.
All right, the court will hear final argument, if there is any.
Your Honor, I think it's clear that Ms. Segundo did not start this incident. That her actions occurred outside the elevator as a result of defending another person. She doesn't deny that she struck Ms. Martinez, but this was a situation where she was struck as well. And we believe that this one incident that wasn't premeditated, it wasn't started or caused by her. You know, it reminds me of a penalty, and another individual comes in their aid, and then another flag comes up for a penalty, and they both get penalties. And most cases in sports, that's offsetting. And I think in this case, at looking at the situation, looking at history since that day, that I think it would be fair to give this single mother a chance to continue her life and being a mother and working at her employment. So not to have this crash down on her with her children, with her workplace. We can't promise that she will keep her job upon this conviction. We cannot promise that she can be able to parent her children and be the primary caretaker of her children as a result of this conviction. But we can promise that if she is given a chance, she will do everything in her power to remain on probation for 7 years, to do what's right, so not to be considered a felon in a situation that she wished never had happened. There's no ill will here. There is no desire on her part to do anything but to to move on with her life and pay what's owed, the $2,500, and do what it takes to win your trust. So we're asking, Judge, that deferred adjudication be given to this woman so that she can continue to do her life and do good for her children and her work and her community.
State, any final arguments?
Your Honor, the concern from the state here is, again, the facts of the case. It's that, yes, she wasn't the instigator, but she chose to take it to this level. It was her choice to take this out on the complainant. It was her choice to get involved against the complainant and to not show restraint. It's the issue that this all started over something very trivial, that if just a little bit of patience, this would have all passed over. That moment that she decided to act how she did has affected the complainant from that day until today. And it's going to affect her past this. That's why the state is asking for probation on this case and for you to not grant her deferred adjudication.
All right. So what is the amount of restitution and who is the restitution to?
It's to Rebecca Martinez and
$2,416.29.
Wait, 2,400?
$16.29.
And also in the plea bargain agreement, it says restitution to,
Jeanette Rojas.
yes.
Your Honor, so we haven't gotten any medical or billing from there. We would ask restitution to be determined on that amount.
All right. So with regards to the restitution to Jeanette Riojas, if there's a restitution amount that's submitted to the court and you all have objections to it, we can have a restitution hearing.
Thank you.
And I'll just write in that there's to be a restitution hearing as it relates to Jeanette Riojas. And I'm assuming she's going to want to transfer to Houston?
Yes, Your Honor.
And what?
It's in Harris County.
All right, Ms. Segunda, I've listened to all arguments. I want you to know I paid very close attention to the arguments that were presented, to the witnesses, and to all of the documents that the court reviewed. I realize that sometimes when things happen, it's just a Snapchat or somebody's life, right? It doesn't mean that the person is a horrible person. And I'm sure if people could go back and change things, sometimes people are serious when they say, if I could go back and change things, I would. Maybe I never would have went to the game. I would have just let the elevator went. I would have taken the stairs. I understand that. But we can't turn back the hands of time, right? And the problem in this case, and one of the things that I'm looking at is the fact that the complainant has serious injuries. And it has nothing, my consideration on whether they're a judge or not, that's not playing any factor in my decision. If she did not have that occupation, let's just say she worked at the HEB, for example, then based upon her injuries, she wouldn't be able to work at the HEB. She wouldn't be able to stock. She wouldn't be able to stand and be a cashier. I don't know what they would have her doing at the HEB. You understand? So her injuries are very serious injuries. And I've read the report that was given to me about her injuries. And I've read the PSI report, and I've read the police reports again in this case, because I always like to review things. So I understand that you're very sorry for what happened, but sometimes, yeah, it's great that you're sorry. It's great that you've internalized things, but there is still some punishment associated with it. And I understand that sometimes when people have felony convictions, they say, well, now I can't do this. I can't do that. I can't do this. But then when you look at the complainant has some lifelong issues. And that's the report that I was given and that your attorney has read. The injuries that she suffered are not going away. And from the report I read, it sounds like they're never going away. She's always going to have those injuries. And I think you know that when people have broken bones, there's a change in the weather, their bones ache. I have it with my fingers because at one point in time, all my fingers were broken. on my left hand. So I know when the weather is changing, it gets a little bit painful, not unbearably painful, but it does. So those are a whole host of things that happens when somebody suffers the injuries that she suffered. I understand, as I said, that you're sympathetic, and I believe that you're sympathetic, and if you could do things over, you would. But I am where I am right now, okay? All right, this is what the court is going to do. Court will find you guilty, sentence you to 7 years in the prison, suspended and probated for 5 years. There's a $500 fine that will be probated. There's a transfer to Houston, Texas, Harris County. Taking consideration County Court Cause number 693701. There's to be restitution of $2,416.29 to Rebecca Martinez. There's to be no contact with Rebecca Martinez or Jeanette Riojas. Proof of employment within 45 days. There's to be no employment as a home health care provider with minors. 100 hours of community service restitution. That'll be waived once you complete parenting classes. There's to be regular reporting by Zoom or in person, regular UAs, and restitution hearing as it relates to Jeanette Riojas. I don't see this as an anger management situation. I see this as an aberration. I think she doesn't need anger management classes. So is there anyone going to object to me not giving her anger management classes?
The state won't object, Judge.
All right. Probation, is there anything else she needs?
No, Your Honor.
Is there anything else you need from the court to be successful? All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yeah.
All right. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sure.
All right, we can go off the record. So what I've learned in my time on the planet, it's just best when somebody says, oh, you can't do that, and you want to argue about it, pick another day to argue about it. You understand? All right, good luck to you.
Thank you.
The ruling is measured and heavy. Guilty. 7 years suspended. 5 years probation. Strict conditions. Restitution. Employment limits. No contact orders. This is not leniency, and it's not incarceration. It's a legal middle ground acknowledging both accountability and rehabilitation. The judge makes one thing unmistakably clear: remorse doesn't erase damage. Apologies don't heal broken bones. And consequences must reflect the permanence of injury, not just the moment of regret. So now it's your turn. Do you think probation was the right call, or should prison time have been on the table? If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.